This program is not intended to replace professional legal advice or representation. If you have a legal concern, you are strongly encouraged to seek the advice of an attorney.
Hello, I'm Yanique Otto, attorney at law in South Florida with the Otto Law Group. Thank you for joining us for this episode of Now You Know the Law. So you're involved in a family lawsuit, maybe a paternity matter, a divorce, or something involving child support. There's been a lot of paperwork going back and forth, and most recently, you've been served with something called mandatory disclosure. It's asking you to produce a whole host of financial documents. You're confused and wondering why you have to turn over all of these documents. I mean, what does all this have to do with my case? And moreover, why do I have to give her my documents and she hasn't given me anything of the sort? Well, here's what you need to know. In Florida, a family law case, whether it involves child custody, support, paternity, or a divorce, always begins with the filing of a petition with the courts. The other side will have 20 days to submit a response once the petition is served. They can simply file an answer, or they can make a case of their own by filing a counter petition. Once the petition, answer, counter petition, and answer to the counter petition have all been filed, the next phase is called discovery. In the discovery phase, both sides must submit financial affidavits to the court and provide them with the opposing counsel or spouse or parent as well. Additionally, each side must also provide the other side with what's known as mandatory disclosure. In other words, you must provide documentation supporting the things that you put in the financial affidavit. Mandatory disclosure, as the name suggests, is not optional. Both parties must comply with turning over their income tax statements, bank statements, credit card statements, pay stubs, W-2s, 1099s, deeds, titles, insurance policies, and anything else supporting your income, assets, and debts. So when one party refuses to comply with mandatory disclosure, the other may file a motion to compel and have a hearing in which the judge will decide whether there's a good enough reason why mandatory disclosure should or should not be produced. In most cases, the judge is going to rule that it should be produced, and they're also going to award attorney's fees to the side that had to file the motion. So here's the bottom line. Sometimes, for a variety of reasons, clients are not comfortable providing this information. Maybe you feel weird or funny about exposing your assets and your financial information. But invariably, you will be ordered by the court to provide the disclosure, and sometimes to pay the opposing fees, attorney's fees rather, if they had to force you to do it. So, think long and hard about whether you have a good reason not to disclose it, and if so, go ahead and do it. If you are facing a family law legal issue, give our office a call and we can help you. Thanks for joining us, and we'll see you next time. I'm Yanique Otto, and Now You Know the Law.
Now You Know the Law is brought to you by the Otto Law Group. If you have a legal question, give us a call. We'll either help you with the matter or put you in touch with someone who can. To have your questions answered in one of our episodes, you may submit them via our Facebook page at facebook.com/Otto Law Group. The Otto Law Group, providing legal solutions.